In this video, we'll be going over IRS Form 1310, Statement of Person Claiming a Refund Due a Deceased Taxpayer. So according to the IRS, taxpayers may file IRS Form 1310 under certain circumstances when a decedent has tax refund owed to them. The tax refund or the tax return in question may or may not have been filed, and we'll cover some of the situations in which you would either need to file or you would not have to file. So before we go through the mechanics of completing this form, let's talk about who must file this tax return or the Form 1310. So if you're claiming a tax refund on behalf of a deceased taxpayer, you must file this form if you're not either the surviving spouse that's filing an original or amended tax return with the decedent, or if you're not a personal representative filing on the decedent's behalf an original tax return. The next step of that would be if you're the personal representative, you would normally file that tax return with a court certificate showing the date of your appointment. So the IRS also defines for the purposes of this form that a personal representative is the executor or the administrator of the decedent's estate as appointed or certified by the court. So a copy of the will of the decedent alone cannot be accepted as evidence that you're the personal representative, because just putting a copy of the will does not answer the question of whether or not that will had been accepted by a court. So the acceptance by a court is basically the end result of the probate process. So in other words, you can't claim to be a personal representative if there's a possibility that someone can come in with a more recent version of a will that would prove your case wrong. So the IRS needs documentation that this has been certified in a court according to the state laws that apply to the decedent's estate. So the example that the IRS shows of when you would not need to file is if we'll use the names here in this form, but if John Doe here had passed away on January 4th instead of this date right here. So if he had died on January 4th and he did not file his tax return, but then someone other than Mary Jane Doe was appointed as a personal representative and that person filed the Form 1040, you would not need to file Form 1310 to claim the refund. You would just attach a copy of the court certificate showing your appointment. And Mary Jane Doe would not need to file Form 1310 except in special circumstances. So these special circumstances we'll get to in Part 1 because Part 1 kind of lays out the different circumstances in which you would be completing this form. So there are 3 parts to this tax form. They're pretty straightforward. Part 1 is the status or the relationship that the claimant has to the taxpayer or the decedent. Part 2 is optional unless you are neither the surviving spouse or a court-appointed representative, in which case you have to answer a series of questions so that the IRS has a better understanding of where this tax refund is going to go, and most importantly, an assurance that it will be promulgated or dispersed to the decedent's estate. And then Part 3 is the signature and verification form. So let's go to the very top with the taxpayer information. So let's just say that John Doe here was a taxpayer that filed based on a calendar year. If that's most taxpayers, by the way. So if there was another tax year that would apply, you would simply say something like, let's just say that John Doe was a fiscal year taxpayer and he filed based on the federal government's fiscal year. That's what this would look like for a fiscal year taxpayer that celebrates the end of the fiscal year on September 30th. So you would enter one or the other. You don't need to enter both, but that's how that would look like for a fiscal year taxpayer. So we're going to enter John Doe as the name of the decedent. So if John and Mary pass away within quick succession and their tax refund needs to get dispersed to their estate, then the executor or the personal representative would need to complete Form 1310 for John Doe and then a Form 1310 for Mary Jane Doe. Enter the date of death. In this case, John Doe died on the 1st of May, 2024. We enter his social security number. In this case, Mary Jane Doe is the person that's claiming the refund, and they live at 123 Anywhere Road. And then she would check box A in part 1. So once you put the address down here, let's go over part 1. And so part 1 is the box that most applies to you as the claimant. Since Mary Jane Doe is the surviving spouse, she would need to file this form in the case that a refund check had been issued in both hers and John's name. So let's imagine that they file paper tax returns. John likes to receive a check. He does all the taxes, but then he passes away, and for some reason the check is made out in both of their names, and Mary Jane's bank won't accept it because it's got John's name on it. So in this, now this doesn't happen a whole lot. Most banks would probably accept a refund check, but deposited by one spouse or the other. However, some banks have policies on how to process certain transactions once they've been notified of someone's death. So in this case, Mary Jane notified the bank, but then received this check. The bank said she needed to have the refund check issued in her name only. And so she's going to file this form, and then she's going to mail back the refund check to the IRS. She's going to mark it void, and then she can either take it to her local office or she can mail it to the IRS center where she filed her tax return, as well as a written request for a reissued check. So then she would get the new check issued in her name by mail. If you check Part B, this means that you're a court-appointed or a certified personal representative. As we discussed previously, you would attach a court certificate showing your appointment. Again, the will is not enough. It's the court certificate saying that you're the appointed person, and presumably that would be based on your version of the will being the one that prevails. So if you select either Part A or Part B, you don't need to complete Part 2. You can simply go down to Part 3, sign it, date it. You can enter your telephone number if you wish, but it is optional. It might be prudent to do so that the IRS can follow up if there are any minor questions. So in Part 2, if you're not the personal representative and you're not the surviving spouse, maybe you're a beneficiary. And maybe you're the only beneficiary. So you know that at some point you're going to receive the check. And if you're the only beneficiary, then there's probably not a whole lot of contention, but this will help you navigate through this form. This is the reason I'm redoing this video, is because there have been questions that people have asked specifically about this. So if I were a sole beneficiary of the will, knowing that all the assets are going to come to me, I still need to answer the questions properly so that the IRS, will issue me the refund. So in this case, did the decedent leave a will? I would mark yes. has a court appointed a personal representative for the estate of the decedent? So if you answer yes here, and you're not the court appointed representative, then you can't fill this out. You would have to be the court appointed representative, and you would complete part B, which means you don't need to complete part 2 at all. So let's just say that the court has not appointed the personal representative. Now, if you answer no to question 2A, will one be appointed? So if you answered no to the first one, you should be fairly positive that they're not going to appoint someone for the second part. And then if you answered yes to either of those 2 questions, line 2A or 2B, just know that if you're not the personal representative, the IRS won't accept this form from you. Line 3. So if there is a will but there's no personal representative and you're claiming the refund, will you pay the refund according to the laws of the state where the decedent was a legal resident? This is what I would consider pretty much a trick question. So if you answer no, then basically you're not going to get the refund, and you're going to have to then go back and submit a court certificate showing your refund or your appointment as the personal representative. The IRS will just sit on that until you prove to them otherwise. So the only answer here is yes. So for people that are concerned about that, let's play this out. If there was a will and you're the only beneficiary of the estate, then you're going to pay the refund to your estate, but it's going to come to you anyway. So you shouldn't really feel like there's steps that you need to walk through, but at the end of the day, you're going to get everything that you're entitled to. And this is also to prevent someone from answering identically in this situation, and you happen to have 2 beneficiaries instead of just a sole beneficiary, and one person decides to file this form and cut the other one out. So that's the safeguard that the IRS has. And in part 3, you're swearing this under penalties of perjury. So if the IRS finds out that you lied on this, they can actually come back and hold you personally responsible for and impose tax penalties on you. So there is the catch-all under penalties of perjury. That means that you're not misrepresenting the estate here. So everything is true, correct, and complete to the best of your knowledge. So basically, you would file this form. You may file this form under, let's go back to Part B for a second. So you would check this if you're the decedent's court-appointed or certified personal representative and you're claiming a refund on either an amended tax return, which is filed on 1040X, or Form 843, which is the request or a claim for a refund and a request for abatement. So in this case, you would attach the court documentation. If you've already submitted a court certificate to the IRS, you don't need to resubmit it. You would simply complete the form and then write certificate previously filed at the bottom of the form. So you can probably put it here, or you could put it here. I'm sure if you talk to 5 different accountants, they would probably tell you 5 different places that they would put that. So, and then you would either file this with the IRS office where you filed your tax return. If your original return was filed electronically, you can mail it to the IRS center that's designated for the address indicated up here. So, or if you're attaching this to another form like Form 843 or your amended tax return, you would simply follow the instructions for filing there. You can, if you're a surviving spouse, you can always bring this to your local IRS office. So those are your filing options. So that's all we have for this tax form. We will put links in the show notes to both the article for this tax form and then also articles and videos we created for the other tax forms that were mentioned here today. So if you like our articles, please subscribe to our newsletter. If you like our YouTube videos, please subscribe to our YouTube channel. And as always, if you have any questions or comments, or if there's a topic you'd like to see discussed in an upcoming video, hit me up in the comments section. Thank you very much and have a great day.